Justice isn't blind. Not anymore. The note had no return address.
No fingerprints.
Just those 6 words, typed in serif font on thick cream paper, folded once, and left in the drawer of Justice Amy Coney Barrett's private chambers. She found it after oral arguments in Westgate versus United States, a case that should have been mundane. But something felt off. The shift didn't start with the note. It started with a look. During the hearing, as Barrett laid out her opinion on the constitutional limits of federal education mandates, Justice Ketanji Brown Jackson had smiled. Not politely, not collegially, but with the sly confidence of someone watching a chessboard 3 moves ahead. Barrett noticed it. Noticed the way Jackson's fingers tapped idly on her bench, like she'd already written the dissent before the arguments even ended. That night, Barrett reviewed the preliminary drafts of the opinion. On page 14, a clause that hadn't been there before. Urgent moral duty of the state. Barrett paused. That wasn't her phrasing. It wasn't constitutional language. It was rhetorical, activist. The phrase hadn't come from her clerks. It hadn't been in any prior draft. And yet, it was embedded in her own majority opinion. She picked up her phone. Thomas, I need you to run a line-by-line audit of every document passing through our shared server. I want IP logs, access trails, and find out if Jackson's clerks are using side channels. Thomas Rourke, her senior clerk, had learned not to ask questions. He just replied, "Yes, Justice." Barrett leaned back in her leather chair and exhaled slowly. This wasn't a leak. This was a message. 2 days later, Barrett encountered Jackson in the narrow marble hallway between chambers. The air was cool, the silence surgical. That was quite the dissent, Barrett said. Jackson's gaze held. The Constitution breathes, Amy. I'm just making sure it doesn't suffocate. Are you rewriting it? Or reinterpreting it? Maybe it's time the court stopped following and started leading. They passed each other, shoulders barely inches apart. The sound of distant footsteps echoed like a ticking clock. Later that evening, Barrett reviewed internal memoranda from the Jackson chambers, at least the ones officially archived. She found 3 versions of the same opinion draft with subtle but consistent changes to precedent language. Judicial restraint had been replaced with judicial obligation. Strict construction had shifted to progressive realization. It wasn't just rhetoric. It was doctrine under transformation. Barrett pulled a yellow legal pad from her drawer and began drafting a memo. Not to the other justices, but to herself. Notes, counternotes, constitutional references. She didn't like what she was thinking. A court divided is one thing. A court quietly hijacked is another. Jackson, meanwhile, was on a secure video call from her chambers with 2 professors from Yale Law. We can't rely on Congress. Not this session, not next, said the man in the top left box. You think the court can shift public will? Not public will, Jackson replied. Public framework. If we can move the language of law far enough left, the next generation won't argue about what the Constitution says. They'll argue about what it means in a just society. But Barrett, she'll sense it. She already has. But she'll fight fair. That's her weakness. The next morning, a plain brown package arrived at the Supreme Court's central intake.
No postmark. No sender.
Inside was a small audio recorder. A single file. Jackson's voice. And once we shift the doctrine, even Barrett won't be able to stop it. Written across the envelope in black Sharpie. Whistlebench. Barrett listened twice. Then she stood and locked her office door. The door clicked shut behind her with a finality that echoed louder than it should have. Amy Barrett stood motionless in her chambers, the audio recorder still in her hand. Jackson's voice repeated in her mind like a legal siren. Even Barrett won't be able to stop it. There were rules, boundaries. The court wasn't a political body, or at least it wasn't supposed to be. And yet, Barrett could feel something tectonic shifting beneath the marble floors. This wasn't about one opinion or one case. This was about the court itself being slowly reprogrammed. Line by line, ruling by ruling. She placed the recorder in a locked drawer and turned to her handwritten notes. There, in black ink, underlined twice. If doctrine shifts silently, who's watching the watchman? Across the hall, Jackson's chambers were alive with quiet purpose. Her clerks worked with monk-like intensity, redlining text, analyzing 5-4 splits from the last decade, reviewing precedents ripe for reconsideration. Jackson paced slowly between them, her heels whispering across the carpet. "The public won't read the opinions," she said aloud. "But academics will. Law students will. And they'll echo us in journals, classrooms, on the bench 20 years from now." One of her clerks, Sasha Ndlovu, looked up. "You think Barrett suspects?" "She suspects everything," Jackson replied. "But she doesn't know how far I've already gone." The next hearing came fast, Williston versus Department of Health and Human Services. A case centering on whether a federal agency had overstepped by issuing emergency healthcare mandates. A bureaucratic question on its face. But deep underneath, a war over executive power. Barrett delivered her questions with surgical control. "Where in the Constitution," she asked the government attorney, "does Congress grant agencies carte blanche to define emergency doctrine without legislative input?" Jackson responded with a question of her own, during her line of inquiry. "Is the Constitution a fixed blueprint, or a mirror reflecting the crisis of the day?" Barrett didn't react outwardly, but she felt it, the ground shifting again. Later that night, Thomas, her clerk, entered her chambers with a flash drive. "I got what you asked for," he said quietly. He plugged it into her secure terminal. Logs, redline drafts, internal memos, some routed through off-site servers tied to a public interest law firm in D.C. That firm was known for its connections to legal scholars who advocated for interpretive evolution. Barrett clicked through one draft dated 3 weeks before arguments even began. Jackson had already written a dissent, not based on the case, based on the anticipated reaction from the media. A soft "damn it" slipped from Barrett's lips. This wasn't jurisprudence. It was preloaded politics masquerading as law. The next day, Barrett walked straight into Chief Justice Roberts' office. She's trying to bend doctrine through external influence, social commentary, academic reach, pre-argument narratives. "I have proof," she said, handing over a transcript and server map. Roberts rubbed his forehead. "You're asking me to accuse a fellow justice of ideological tampering, Amy. I'm not asking. I'm warning." That night, in her own chambers, Jackson received an anonymous envelope. Inside, a photo of Barrett meeting Roberts. On the back, scribbled in red ink, "She knows." Jackson closed the envelope slowly. Then she smiled. It wasn't just a headline. It was a rupture. Internal power struggles rocked the court. Barrett, Jackson, and the fight for America's legal soul. The article dropped at 6:02 a.m. By 6:45, it was trending across every political feed in the country. Conservative commentators praised Barrett as the last guardian of constitutional integrity. Progressives rallied behind Jackson as the voice of a new judicial age. Cable news lit up. Podcasts exploded. Talk radio declared war. By 8:10 a.m., Chief Justice Roberts convened an emergency meeting. Barrett was already seated when Jackson walked in, composed, silent, her lips drawn in the slightest curve of self-control. They didn't look at each other. "Not yet." Roberts, stern, paced. "This institution survives on trust. This," he pointed to the article on a printout, "shatters it. No one admitted to the leak. No one had to." Roberts continued. "Until further notice, all draft opinions are restricted to paper format.
No emails.
No shared drives. Physical signatures on all revisions. We go analog." Barrett nodded. Jackson didn't. Outside, protesters gathered within hours. One side chanted, "Protect the court." The other, "Let it evolve." The marble steps had become a battlefield for ideologies. But the war began behind the veil. Inside her chambers, Barrett read the article 3 times. They had details no reporter should have had. Internal language, timestamps, even fragments of her private memo, the one only Thomas had handled. Unless, she picked up the phone. "Thomas," Get in here. The young clerk entered, pale. I swear, I didn't. Barrett held up her hand. You didn't leak it. But someone else in the system did. Then she paused. Did you notice anything unusual in Jackson's staffing logs? Any externs? Any visitors? Thomas hesitated. There's a name. Elise Kerwin. She's not officially on the docket, but her ID was flagged twice near the secure document room. Barrett's eyes narrowed. Find out who she is. Meanwhile, in her chambers, Jackson met with Elise behind a closed curtain. You were careless, Jackson said. I thought the timing was right, Elise replied. The narrative favors you. The public sees Barrett as rigid. Your progress. That's not the game we're playing. Elise frowned. Then what are we playing? Jackson's tone dropped. We're rewriting history by writing precedent. Not headlines. She turned away, but not before Elise caught a flicker of doubt in her mentor's eyes. That night, Barrett met privately with Justice Alito. He listened carefully as she laid out the infiltration. She's not just reshaping doctrine, Barrett said. She's training operatives. Embedding them. Alito exhaled. Do you have a plan? Barrett nodded. Not just to stop her. To expose her. But Jackson wasn't waiting. 2 days later, her descent in Williston v. HHS dropped early, intentionally. It was unconventional, sweeping, filled with language meant for more than just the legal elite. Phrases like evolutionary necessity, structural compassion, and constitutional elasticity peppered the opinion. Twitter blew up. Law schools shared excerpts. By the evening, CNN was calling it the manifesto of the modern court. Barrett watched the coverage with stoic calm. Then she opened a fresh legal pad and wrote at the top, "Precedent can be erased, but exposure is permanent." She picked up the secure phone. "Activate the channel. I'm ready to go public." Barrett stood at the edge of the press storm she had detonated. The video, Benchgate File 01, was everywhere. Shared in legal forums. Replayed in congressional offices. Whispered about in think tanks and war rooms across D.C. A digital specter hovering over the Supreme Court, casting doubt on the integrity of the institution. And it was only beginning. She knew she had crossed a line, but she also knew something deeper Jackson already had. The morning after the leak, Barrett received a handwritten note. It had no signature, no envelope, just a sentence scrawled across a torn piece of an opinion draft. Truth is interpretation, and history will remember who authored the better one. She recognized the handwriting instantly. Meanwhile, Jackson was already 2 moves ahead. Her clerks were reorganized. The old ones replaced by sharper, younger minds, graduates of programs where legal theory and social philosophy blurred. They didn't just study law. They studied impact. Doctrine, she told them, is not set in stone. It's wet cement. And this, she held up the Constitution, is the mold we fight over. They nodded, reverent. Jackson had moved from dissents to strategy memos. Not for the court. For academia, NGOs, state legislators. She was seeding ideas, talking points, legal blueprints. She was building a movement. Barrett met in secret with 3 former clerks turned federal appellate judges. In a private D.C. apartment, she laid it all out. Coordinated language shifts, early media seeding, off-the-record briefings with activists. She's crafting a parallel jurisprudence, Barrett said. A legal narrative that lives beyond rulings. One of the judges, Mark Whitaker, leaned in. Then we fight the narrative. Counter it case by case. Barrett shook her head. It's not enough to counter. We need to reset the battlefield. Across the city, at a closed-door symposium, Jackson took the stage. Her talk wasn't recorded. Phones were banned. But one sentence was carried out by every attendee. The law does not merely reflect the nation, it directs it. And it's time we choose the direction ourselves. The applause was quiet, intentional, powerful. Days later, Barrett filed a procedural motion. It seemed harmless. A request for an expedited hearing on a relatively minor administrative case. But buried in the appendix was something else, a legal argument designed to box in Jackson's interpretive logic. If the court accepted it, it would establish a precedent limiting how far a justice could go in redefining legislative intent. It was the first real shot. Jackson read the filing that night. Alone. Silent. She didn't rage. She didn't panic. She smiled. Then she reached for a sealed folder labeled Project Helix. Inside, memos, white papers, talking points, each one linking modern judicial interpretations to broader civil movements. She wasn't just fighting for law. She was preparing to become the law. You wanted a war of words, Amy? Jackson whispered to herself, closing the folder. But I came to rewrite the language. The Supreme Court was no longer just a courthouse. It was a battlefield disguised in black robes. Barrett walked past the portraits of justices long gone, Marshall, Rehnquist, Scalia. Men who, for better or worse, had fought their battles in chambers, not in the streets or on screens. But this was a new era. Her motion had been accepted. A minor victory, yes, but it cracked open a door she could now wedge her foot into. The precedent she'd seeded would corner Jackson's interpretive flexibility, limit the oxygen, reinforce the originalist frame. But Jackson didn't flinch. She pivoted. In a closed session, she delivered an opinion that shocked even her own allies. Not because of its outcome, but because of how she wrote it. She cited literature, social science, emotional impact. She mentioned a victim by name. It was brilliant, and it was dangerous. Barrett read the draft 3 times. This wasn't dissent. This was storytelling disguised as law. And the public devoured it. News anchors praised Jackson for humanizing the bench. Students quoted her like scripture. Advocacy groups turned her phrasing into slogans. When precedent protects injustice, we owe the future a rupture. That line alone trended for 48 hours. In her chambers, Barrett paced. She's not arguing. She's narrating, she said to Thomas. She's turning rulings into manifestos, he replied. Barrett nodded. And she's pulling the country with her. Barrett returned to the archives, the old, dusty rulings no one cited anymore. She searched for fractures in the old system. Proof that story without foundation is still just fiction. She found a case from 1936, Ashland versus Carrington. A forgotten ruling about narrative overreach and judicial overstep. It was the counterweapon. She began crafting her own opinion, not as a rebuttal but as a reset. Titled simply, On the Dangers of Lyrical Law. It wasn't subtle. It wasn't warm. But it was fireproof. And it leaked. Jackson read it the next morning over black coffee and silence. The title alone was a shot across the bench. She closed her laptop and looked out her window at the growing line of protesters beyond the fence. Some held signs quoting her. Others carried photos of Barrett. The nation had picked sides. Meanwhile, a private memo surfaced from within a federal circuit court. Speculation that the Supreme Court itself might soon fracture in legitimacy. Politico published an exposé titled, A Court Divided. Can 9 justices still hold the center? The White House issued a statement urging judicial restraint. The Senate Judiciary scheduled an emergency hearing on judicial norms. And at the center of it all were 2 women, one bound to the text, the other reshaping its soul. Barrett attended a quiet Sunday mass. No press.
No clerks.
Just silence. As she lit a candle, a parishioner slipped a note into her hand. Your law is logic. Hers is emotion. But the country bleeds in both. She didn't react, but her resolve hardened. As Jackson walked to her car that night, a voice called out from the shadows. They're not here for the law anymore, Justice. They're here for the revolution. The revolution had a face now, and it wore a robe. Barrett watched the broadcast from her chambers. Jackson speaking at a legal symposium in Chicago. Cameras rolled. Microphones were hot. Every word crafted with precision, but delivered with the ease of someone who no longer feared consequence. Our interpretation of the Constitution must pivot, must evolve, not only to serve justice, but to survive relevance. The audience erupted. Students, scholars, politicians. It was no longer about law. It was about momentum. Jackson didn't just command the room. She redirected the compass. Barrett closed the laptop slowly. It was time to change the rules. The next day, Barrett took an unprecedented step. She met with Senator Harrington of the Judiciary Committee behind closed doors. There needs to be a public record, Barrett said flatly. A line between law and influence, between philosophy and seduction. Harrington raised an eyebrow. Are you asking for congressional intervention? I'm asking for boundaries, before the robes turn into pulpits. Word of the meeting leaked within hours. Cable networks went berserk. Justice Barrett sounds alarm. Judicial revolution in progress? Barrett versus Jackson. Who owns the Constitution? Is the court becoming a political weapon? Inside the court, the atmosphere grew tense. Justices no longer lingered after hearings. Doors stayed closed longer. Side glances carried weight. Rumors swirled that Justice Sotomayor had sided with Jackson off record. That Alito was preparing his own internal memo. That Roberts had considered stepping down. The court had become an iceberg, only a fragment visible to the world, but deep beneath, the fracture lines were spreading. Jackson remained undeterred. She launched what she quietly called the pivot doctrine, a series of dissents written not to win the case, but to shape the next one, each layered with rhetorical scaffolding designed to anchor future courts to today's moral tide. It was legal seduction, and it was working. Her clerks called it forward jurisprudence, law not for today, but for the ideology of tomorrow. Barrett called it something else.
Judicial insurgency.
In response, Barrett crafted an opinion so clinical, so brutally text-bound, it read like a scalpel. The Constitution is not a suggestion. It is a structure, and structures do not sway with sentiment. They stand or they collapse. Some called it cold, others courageous, but it lacked the poetry that Jackson now wielded like a sword. Barrett didn't care. She was writing for the record, not the audience. Late one night, a package arrived in Jackson's office. No return address, just a legal pad. On the first page, a single line. When the people chant your name, remember, the mob is loudest right before it turns. Jackson stared at the note. For the first time in weeks, she didn't smile. 2 days later, a protest outside the court turned violent. Fights broke out. Police intervened. A clerk from Barrett's office was injured. Someone had burned copies of both justices' opinions on the steps. America wasn't just watching anymore. It was reacting. That evening, as Barrett reviewed security footage of the protest, she paused on a frame. A protester holding a sign that read, 9 justices, 1 future. Whose? Her reflection flickered in the screen. And for a moment, even she didn't know the answer. The marble columns of the court had never seemed so fragile. Barrett entered through the east entrance. Avoiding the media, the chants, the smoke. She didn't flinch at the broken glass by the side gate. But she noticed it. The symbol. The slow erosion of something sacred. Inside, the court's air was different now. Charged, uneasy. The whispers of clerks carried more than case chatter. They carried fear. This wasn't dissent anymore. It was war. Jackson sat alone in her chambers, rereading a letter she'd once received from Justice Breyer on her appointment day. It spoke of humility, duty, and the quiet power of restraint. Words she had admired then. Words that now felt like chains. She folded the letter and placed it in the drawer. Restraint no longer served the moment. Not when the moment was bleeding. Behind closed doors, the justices met for conference. The upcoming case, Freeman versus Federal Oversight Board, was technically administrative, a conflict over the limits of federal authority in state financial crises. But everyone in that room knew this was the line in the sand. The case hinged on one principle. Can the court redefine structural limits in light of modern equity? Barrett's eyes locked with Jackson's. Everything else fell away. Barrett spoke first. If we allow context to rewrite architecture, then architecture is nothing. Jackson followed without pause. If we prioritize structure over humanity, we risk building fortresses around cruelty. Silence. Roberts rubbed his temple. We're not here to rewrite America's soul. We're here to interpret its framework. Barrett replied, quiet but sharp, The framework is the soul, Jackson. Then maybe the soul needs rewriting. After the conference, Barrett walked the empty halls, her heels echoing like a metronome. At the base of a clerestory window, she found a note tucked into a copy of the Federalist Papers. We fought a revolution over law once. You'd do well to remember which side wrote the new rules. She didn't recognize the handwriting, but she recognized the threat. The night before oral arguments in Freeman, Barrett gathered her clerks. We are not writing an opinion, she told them. We are building a firewall. She drew 3 circles on a legal pad. The center one marked text, the second intent, the third legacy. This isn't about winning, it's about anchoring. Meanwhile, Jackson met with a team of law professors via encrypted call. We push, harder than before, she instructed. This ruling must breathe. It must live. She unveiled the opening line of her draft. When history calls the law into question, the court must not answer with silence. In the gallery the next morning, press and staffers leaned forward as the justices took their seats. Barrett's opening statement was crisp. The Constitution limits not because it distrusts progress, but because it protects us from zealotry disguised as progress. Jackson followed. This nation is not built on fear of change. It is built on change. Fear is what kept us from liberty for centuries. The chamber was silent, but outside the country roared. That night, a masked whistleblower published the Freeman internal draft opinions. The leak included margin notes, annotations raw, untouched. The public now had what it was never meant to see. The minds of the justices in real time. And they weren't just divided. They were combustible. The leak detonated like a legal bomb. The Freeman drafts, every margin note, every highlighted clause, every whispered fear scribbled in ink, spread across the internet within hours. Legal scholars gasped.
Komentators spun.
Protesters returned to the court steps. But now, they weren't just chanting. They were choosing sides. Barrett's originalist precision was there in black and white, clinical, deliberate, built on the skeleton of centuries. She had written, history is not a burden. It is a boundary. And without boundaries, justice is merely ambition. Jackson's draft pulsed with energy, like a heartbeat on paper. Law is not a wall, it's a vessel. And we are duty-bound to fill it with what we dare to believe is better. 2 doctrines, 2 Americas, and only one ruling. Inside the court, the tension could be cut with a breath. Barrett reviewed her final opinion, now stripped of staff edits. She'd rewritten the last paragraph herself, by hand. She paused before reading it aloud to the bench. Then, the text is not a prison. It is a promise. But promises must be kept, not reinvented. Jackson, in response, delivered a concurring dissent. Not in tone, not in manner, but in conviction. If a promise fails to serve the people it was made for, it is not sacred. It is abandoned. The gallery was dead silent. Outside, the nation braced. The ruling was split. 5-4. Barrett prevailed. Her firewall held, for now. But it wasn't a victory. Not when cable news called it the last stand of the old court. Not when thousands marched that night holding signs reading "Rewrite the Rules." Not when Jackson's dissent went viral, excerpted and quoted across classrooms and boardrooms alike. She had lost the case, but she had won the story. Barrett sat alone that evening, her office dim, her reflection staring back from a wall of framed legal texts. Thomas entered quietly. "You okay?" She didn't answer right away. Then, "She's not done. This isn't over." He nodded. "Then neither are we." At the same moment, across the city, Jackson walked through a packed university auditorium. Students rose to their feet. She took no podium, just stood in front of them and said, "The ruling came down, and yes, we lost. But if you read the dissent, if you understand it, then you know we're only just beginning." The applause shook the room. History had heard her. 6 months later, the Freeman dissent was cited in 2 circuit rulings. Then in a state court opinion. Then, at a convention of law students drafting a new interpretive model for equal access jurisprudence, Barrett watched it unfold from afar. And in a quiet entry in her journal, she wrote, "The Constitution will outlive us, but the war over its meaning never ends. And sometimes, it is not the ruling but the resistance that reshapes the law." On the anniversary of Freeman, a statue was unveiled outside a law school in Atlanta. It depicted two figures in robes standing back to back. One held a scroll, the other a torch. The plaque read, "In the court of ideas, both fire and form leave their mark.